Guys, today we are going to discuss the general provisions and defined obligation as a juridical necessity to give, to do, or obligation not to teach in a particular perimeter of a particular land because it is obligation is considered to be a juridical necessity. Perform this obligation, then the other party are to the court a real obligation, and the person is not necessary that you will be the one to the obligor himself should perform the so thus you should be the one or one in an obligation to give the creditor the debtor if you fail to deliver the date and money are delivered to you. So what is the remedy to what the creditor if the debtor and being liable for the salaries of for the salaries and damages. Good morning, guys. Today we are going to discuss the general provisions and the law on obligations. The general provision starts with the definition of the obligation, and the Civil Code of the Philippines defined obligation as a juridical necessity to give, to do, or not to do. So basically, from the definitions, there are three obligations. That is an obligation to give, an obligation to do, or an obligation not to do. Let's say, for example, an obligation to deliver a car is an obligation to give. An obligation to teach in a particular university is an obligation to do. An obligation not to fence the perimeter of a particular land because it is subject to a right of way is an obligation not to do. From the definition also, obligation is considered to be a juridical necessity. Why is it so? Because when one of the parties will not perform his obligation, then the other party may go to the Court of Justice to ask the court to compel the other party to perform the obligation. Generally, from the definitions, there are two general classifications of obligation, which are a real obligation and a personal obligation. An obligation to give is a real obligation, while an obligation to do or not to do is a personal obligation. When we talk about personal obligation, it simply means that the obligor should be the one to perform the obligation. In an obligation to give is considered to be a real obligation and not a personal obligation. Just like, for example, if you are obliged to deliver a car, it is not necessary that you will be the one to deliver the car. So you can ask your wife, you can ask your brother or sister or neighbor to deliver the car in your behalf. So that is why in an obligation to give is not considered to be a personal obligation, but a real obligation. However, when we talk about an obligation to do or not to do, this is considered to be a personal obligation, which simply means that the obligor himself should perform the obligation. Let's say, for example, you are contracted to teach in a particular university, so you cannot ask your wife to teach on your behalf because an obligation to teach is depending on your skills and in your qualification. So thus, you should be the one to perform the obligation to teach and not anyone else that you can ask. So what are the remedies on the part of the creditor if it is an obligation to give? So the following are the remedies of the creditor. Number one, in an obligation to give, the creditor may compel the debtor to make the delivery, okay, and demand damages in case of non-performance if the obligation is a determinate thing. Okay. So, if the obligation is to deliver a determinate thing, when we talk about determinate thing, it is a thing that is physically segregated or particularly designated from the rest of its class. So let's say, for example, I promise to deliver my only car. In case I cannot deliver my only car, I cannot deliver any other car, okay, to the creditor. So, because I did not deliver my only car, all right, so I will be liable for damages if I did not deliver it. Second is the creditor may ask that the obligation be complied with at the expense of the debtor if he fails to deliver the thing, and demand for damages if the obligation is to deliver a generic thing. All right. So a generic thing is a thing that is not physically segregated, not particularly designated from the rest of its class. Let's say, for example, if I promise to deliver a car, so I can deliver any car. Okay? I can go to the car showroom, and buy a car and deliver it to you. So it does not need to be my only car. It can be any other car because the car that I promise to deliver is a generic thing. Okay, so what is the remedy on the part of the creditor if I will not deliver any car? So the creditor may ask somebody to comply my obligation in my behalf. Okay, so in other words, if I promise to deliver to you a car and I did not deliver a car, you can ask somebody to deliver a car at my expense. All right. But I don't know in the real practice whether that can be possible. Okay, but the law said, well, if it is a generic thing, okay, such as a promise to deliver a car, then if I did not deliver the car, the creditor may ask somebody to deliver the car at my expense, which simply means he can ask somebody to deliver the car and let me be liable for the payment of the price plus the damages. But in a real situation, as I have said, it may not be practical, right? Okay. So I don't know if there is somebody who is willing to deliver the car at my expense in that case. But the law generally said that it can be a remedy on the part of the creditor. In an obligation to do a credit, if the debtor will not perform his obligation, the creditor may have the obligation executed at the expense of the debtor and demand for damages if the debtor fails to perform or performs it in contravention of the tenor of the obligation. So let's say, for example, if I am obliged to teach, so I am under contract to teach in a particular university, for example, to teach business law subject, okay, and I did not teach. So the university can hire somebody at my expense, which simply means I can be made liable for damages and I can be made liable for the salaries of the salaries and damages that the university incurs because I did not teach the business law class. I did not honor the contract. Okay. Or the creditor have the same be done at debtor's expense and demand damages if the debtor performs the obligation poorly. So let's say, for example, I am a building contractor and you asked me to build a house, and you said that a house should be 100 square meter, has a 100 square meter floor plan, has a 3-bedroom, and has 2 living rooms. Then I constructed a house and it has only 2 bedrooms and has only 1 living room. So it is done poorly or in contravention of the tenor of the obligation. So the creditor, you as the one who hires me as contractor, can have the demolition of the house at my expense. Okay, at my expense, with me being liable also, in addition to that, being liable for damages. So guys, these are the general provisions. There are other provisions in the general provisions that needs to be discussed, but I will cut cut it in this way because the other provisions and the general provisions will be discussed separately. Bye, guys.